This is Court Watch with Alex Swoyer, and I'm excited to bring you the 12th episode of my podcast where I will be joined by Judge Amal Thapar. He is a federal judge on the 6th U.S. Circuit Court of Appeals and was the first appeals court judge to be appointed by former President Trump in 2017. He was also on his short list for the Supreme Court. Prior to joining the 6th Circuit, Judge Thapar was a federal district judge in Kentucky, and he also worked as a U.S. attorney for the Eastern District of Kentucky. He's joining the podcast to discuss his new book, The People's Justice, out on June 20th, detailing Supreme Court Justice Clarence Thomas and his originalist record. Thanks, Judge Thapar, for joining me in the podcast to talk about your new book. It's out this week, and you focus on several stories about people with cases before Justice Thomas in the past and how he used originalism to decide their disputes. I have a couple questions for you just off of that. Why did you choose Justice Thomas out of all the justices? And then also, why did you come up with the title, The People's Justice?
Yeah, great questions. Thank you for having me, Alex. So the first question, when I started the process, I wanted to explain originalism to everyday people. I think the goal was to take it out of legalese and talk about originalism. What I realized when I dove into the cases and dove into the disagreements, and I used to teach a class called Scalia versus Thomas, where Justice Thomas and Justice Scalia would have differences, and we would try and figure out who was right. And it was a lot of fun. But what I found when I recently dove into the cases is Justice Thomas not only had a very originalist point of view, but he also often, if not always, captured that there were real people in front of the court. And as a trial judge, as I was once a trial judge for 10 years and a trial attorney, I knew that about people. But if you get further up in the courts, you often focus on the legal principles at the exclusion of the real people in front of the court. And Justice Thomas always tries to capture those real people, and I think he does it well. And that's why it resulted in the title, The People's Justice, because A, through originalism, he hopes and he thinks, and originalists hope and think they're reflecting the will of the people, not their own will. And the second thing, as I mentioned, is he remembers they're real people, and he often includes little statements within his decisions directed at those people.
Right. And also one of the things I've noticed about his, when he writes it, you don't have to necessarily always be a lawyer to understand, which is important.
Yeah, he always says, why use a $20 word when a $2 word will do? And I think Justice Scalia often used to talk about, that we have an obligation to fly the flag of originalism. And Justice Scalia did such a remarkable job of that when he was talking to lawyers and everyone else. And I think the next step is really to take it to the general public. So you don't need a law degree. And, and this book, that was the goal of this book, to make it accessible, to make it interesting, to bring the stories of the cases themselves to life.
And out of those dozen disputes that you highlight to showcase, the type of jurist Justice Thomas is and his thought process, which one, do you have a favorite, or do you have one that you think is best to share with the audience?
Sure. I'd love to share all 12, but we don't have that kind of time.
Well, they're going to buy the book and read it, so.
Even better. Well, let me just start with the first chapter, since it's the first one that comes to mind. And that is a case called Kelo that some of your listeners may have heard about. But Kelo is a case about Suzette Kelo's home. So Suzette Kelo buys a house in a blue-collar neighborhood, and it's run down. And she gets a second job as a nurse so that she can afford to fix the house. And it's got the perfect view in this wonderful old neighborhood, over 100 years old, in New London, Connecticut. And through blood, sweat, and tears, she turns a rundown house into a beauty. And anyone that's worked on their house knows what kind of personal pride that comes with that. And she's so proud of it. And cost, no doubt. And she paints it Odessa pink. And so she's living happily in this house when she hears and then learns that the Pfizer Corporation is planning to move down the street, but that they want to team up with the city and state to take over the neighborhood and some other property so that they can build a mall and they can have a high-rise apartment building and restaurants. And they want to take away this blue-collar neighborhood and wipe it out. And after she put all this blood, sweat, and tears, no amount of money is going to replace the house she has. So she says no. She wants to fight it. And she challenges the Pfizer Corporation. Now, the problem is that they first have to get lawyers, and they write a ton of letters to one institution in particular, the Institute for Justice, and they ask for them to represent them. And Scott Bullock, the lawyer at the Institute for Justice, flies to New London. He sees this community, this wonderful community, and he can't believe that Pfizer and the city and state are going to take it away. And he files suit on their behalf. And it's not only her. Her co-plaintiffs are people like the Derrys, who lived there for 100 years, who had that house. And when they were so proud of their neighborhood, when their kids got married, they would buy them one of the neighboring houses. So the family had been in that neighborhood forever, and they just wanted to wipe it out. Do you want me to tell you the punchline? Well,
I think you might leave us all hanging if we don't hear it.
Well, then hopefully people will read the book.
Exactly.
But in the this case makes it all the way to the Supreme Court. And Justice Scalia, the book now has a Twitter page, and on the Twitter page we posted this question and answer, so you can hear it for yourself. And if you put the People's Justice in Twitter, you can find it. I don't know how else to describe Twitter to you, so I'm just going to say that, and hopefully people can track it down. But Justice Scalia asked this question: if you take from A, a poor person, and give to B, a rich person, because you think it serves the public purpose, can you do that? And the city says yes. And then he says, wait a minute, just because B will pay more taxes, and I'm summarizing, obviously, and the city says yes. And the question in front of the court was whether the Fifth Amendment, which allows the government to take your property for a public use, also allows the government to take your property for a public purpose. In other words, the Fifth Amendment uses the words public use. And as Justice Thomas explains in his dissent to give it away, public use means taking it for things like sidewalks and roads, not for
a
the
corporation.
Pfizer corporation.
Right. That makes sense, yes.
And what happened is there was a case in D.C. called Berman, where the city took away what they called blighted property for a public purpose, and the court said that was okay. And so they changed the original meaning of the words. The one entity, amongst some others, but the one entity in the Supreme Court that asked for the justices to return to the public use terminology was the NAACP, and you'll see the brief referenced in the book, and I talk about the brief. Only Justice Thomas takes that invitation. It is a 5-4 case, and Justice O'Connor writes the principal dissent for her, Justice Rehnquist, Justice Scalia, and Justice Thomas. But Justice Thomas also writes separately to say how by converting the original meaning to something that's not the original meaning, governments use this to prey on the poor and less fortunate and take their property, and then they admit it, as they did at oral argument. And Justice Thomas points out how this has had a very negative impact on poor and middle-class communities. And in fact, the Berman case in D.C. points out this 97% of the people that were displaced were poor and black.
I'm going to try to ask you about another story in your book, but I don't know if you're going to answer it due to it being another race-related issue, but it's currently pending, and I think you probably know where I'm going. But one of the cases you mentioned is Grutter, and that dealt with affirmative action and the University of Michigan's law school. I know it's pending before the court, so you might not be able to weigh in. Are you able to highlight any of that or give us a prediction on what we might see in the coming weeks? I know you may not be able to speak to this one, but of course it's something that a lot of my readers have been anxiously awaiting.
Yeah, what I would say is in chapters 2 and 3 of the book, so chapter 2 talks about vouchers and chapter 3, affirmative action. And for Justice Thomas, they go together because he does believe it's important that everyone be given an equal opportunity, and that underlies his jurisprudence. And I think if I can, I'll just quote Justice Thomas. That's probably so. What he says in Grutter and what he does in his dissent is he points out and that it seems a little odd that the Constitution. So what Grutter said, I'm sorry for your listeners, is that right now we need affirmative action, meaning back when the case was, I think it was ultimately decided in 2003, if I remember correctly, although that's and Justice O'Connor, writing for the majority, says, well, she gets the reasons that it might not be consistent with the Constitution in 25 years, but today she wanted it, she upheld the program. And she said in 25 years, hopefully we won't need it anymore. And Justice Thomas took issue with this and said, if it's unconstitutional in 25 years, it's unconstitutional today. And so it's a problem today in his mind. And he said, and I'm quoting, the Constitution will mean the same thing today as it will in 300 months. He then goes through and lays out why he believes that affirmative action is not consistent with the Equal Protection Clause of the 14th Amendment. And he and Justice Scalia pointed out an argument that if Michigan had a choice, meaning Michigan Law School, which is what the Regnery case is about, they could either make their standards such that they could ignore the LSAT if that was the problem and take students based on grades and other things and make it equal. And that's all they had to do. They could still achieve the diversity. They just couldn't have all the metrics they wanted and then change the metrics based on your race.
Mm-hmm.
He also, what was important to Justice Thomas in that case, and he points this out throughout his jurisprudence, and on that Twitter page they posted some of the quotes from HBCUs and other things, that if you have something where you're going to mandate a certain level of diversity, you're going to get rid of historically black colleges, which Justice Thomas points out have served students really well. And he pointed to Morehouse College and how well the students do from there. And he just wanted to avoid those types of things in the name of the Constitution when he believed it was unconstitutional. The final thing I'll read to your listeners, if I may, is his fear that by lowering the LSAT standards for one race, the test to get in, but not other races, you forced other races to work towards that standard where you let one race that could accomplish it, as he points out, if held to that standard. And he says this, and I'm quoting, "This racial discrimination will help fulfill the biggest prophecy about black underperformance, just as it confirms the conspiracy theorists' belief that institutional racism is at fault for every racial disparity in our society." And then, if I may add one more thing, when he talks about vouchers in Chapter 2, he points out that the real way to fix what's going on in the universities is to give kids a better educational opportunity in K through 12, because that's really where the fabric is formed of your education.
Mm-hmm. It's interesting. I mean, we're just a few years shy of that 25-year mark that you mentioned from the, I believe it's Grutter case. So I'll definitely be covering the opinion. I'm anxiously waiting, as all the readers are. But one of the things I also heard, I was speaking to a former Thomas clerk, and she had said, for a long time he was like a lone dissent. And now with the current makeup of the court, more originalists on the court, it's becoming, I think court watchers have coined it the Thomas court. Do you think that's fair?
I don't know that it's fair to ever call a court after someone's name. I think the reality is all the justices are brilliant people who are very thoughtful, and I bet all 9 take offense to that, mm-hmm. including Justice Thomas himself. He knows and respects his colleagues and admires all of them. As Justice Breyer said about him, I mean, they were good friends and thought very differently. And so I don't think any judge or justice wants a court to be coined by their name or anyone else's. It is the Supreme Court. Yeah, I like also hearing, I think it's cool to hear about the different friendships, like from Democrat appointees and Republican appointees. We always heard about Ginsburg and Scalia. And then, you hear, I think it was in part of your book I was reading about Sotomayor's praise of Justice Thomas. It's just, it's in a partisan world that we're living in, like very political. It's nice to see that, on the court. I think it helps the public. Yeah, and I really do think it helps. And what I would say about my court, and I would say this all the time, is I love every one of my colleagues. We disagree like brothers and sisters, but we really enjoy each other and enjoy each other's company, and we don't take it personal. In other words, we can disagree without being disagreeable.
Mm-hmm.
And it's one of the hallmarks of the court. And I think part of it is we get to know each other as people. And I think that's so important. I wish more people, instead of just using their views to assume someone that thinks differently than them is a bad person or something, will get to know the person. I always thought one of the great things about law school before COVID and then after COVID is when you come together and get assigned your small section, usually you get to know people before you get to know their points of view. And you become friends with people who might think differently than you. And it's much more fun if you can have those differences and discuss them and not take it personally. And I think the courts really reflect that.
Yeah. I mean, it would be a boring world if we all thought alike. But I do,
Yeah.
I want to ask you, Justice Thomas, he's always been a target from the left. And lately there's been ethics concerns. I know, I don't want to get political or anything, but since you're a sitting federal appeals court judge, I wanted to ask you, there's been talk about potential legislation about a code of ethics. You know, have there been a concern about ethics for the judiciary, or has there been a way for the courts to address these concerns before they come up? Is this just politics, or do you think that there's merit in like some sort of ethics legislation? We
have an ethics code in the Court of Appeals. I'm not going to speak to the Supreme Court in particular since they're my bosses, but I would. The one thing I would say is it's a lot easier for us. If I recuse, there's 13 active judges and 7 or 8. So there's 16 total active judges. So assume you have a panel of 3 and I recuse from a case. You can easily replace it, if that makes sense. We have a plethora of judges from which they can randomly choose and put a third judge on the panel. And so sometimes we catch issues we have to recuse on at the last minute. It's never a problem on our court. At the Supreme Court, there's 9 of them. And when you recuse, what does it produce? It produces 8, which can result in a 4-4 decision. And so I think the justices have to be a lot more careful before they recuse from a case. And as to financial disclosures, I think we're all counseled not to disclose more than is necessary, because then it becomes a game of gotcha. And if it's not required that you disclose X and you disclose it, then everyone asks, why didn't you disclose Y?
Right.
And so I think on the disclosures, we all fill out the financial disclosures and try our best to get it right and do everything in our power to get it right. As to the ethics, we have a code, but it's easier for us to have an ethics code where we can recuse if some issue comes in front of us. So if I spend time with someone, I may list, if I go out with someone, I may list them on my ethics, on my recusal list, just so I never have to worry about it, if that makes sense. But the same luxury doesn't exist and the recusal list, by the way, is separate from the other 2, and we all have those, and they're private because we may put friends on them, we may put others on them.
Right. Circling back to Justice Thomas and originalism in the book, I wanted to say, I thought that, not only did you do a great job of like peeking into a little bit about Justice Thomas and his approach to the law, but also explaining how cases get to the Supreme Court, because you note the sheer volume that don't get heard. And I don't think people kind of realize, the thousands of cases that aren't taken up. So I thought that's also a good part of the read for the public, and how they're interested in how does a case actually get there?
Yeah. And so I think because we have, I don't know what the number is, but in the Court of Appeals upon which I sit, there's 13 courts of appeals, or if you include, 12 that do the work I did, and there's the federal circuit. So you're talking about 13 courts of appeals. And if you think about it, we might decide 8,000 to 9,000 cases between us, but only, and then, or much more than that, I'm sorry, but 8,000 to 9,000 go to the Supreme Court, and then they have to vote to take the case. They review everyone, and they vote to take between 80 and 100 a year. So getting a case to the Supreme Court is almost impossible. It's obviously not impossible, but they're only taking 80 to 100 cases a year. I think one thing also lost on many is how many cases they did not decide unanimously or with what the outside world perceives as strange bedfellows, in the sense that they don't align in the way you typically think they would align if you assign them. There's a very small percentage that are 5-4 or 6-3. But those are the cases everyone wants to talk about.
Those are the ones everyone pays attention to. Right, right. Where can people find the People's Justice? Is it online on the Twitter account you mentioned, or can they go in a local bookstore and buy it?
It's everywhere. You can get it on Amazon, Barnes & Noble, or your local favorite bookstore. It'll be out on the shelf. You can order it on Amazon, and meaning the 19th and 20th, and it's in your bookstores.
Awesome. Thank you so much, Judge Thapar, for your time. Is there anything else I should have asked you about the book or that you want to share that we didn't get to?
The one thing I would say is, the introduction and conclusion are mine, but hopefully I accurately captured in between the 12 stories. And I think people would really enjoy the stories. And I hope if they read it, they do enjoy it. Yeah.
Well, everyone needs a summer read, right? We all need our go-to poolside or beachside after the Supreme Court term ends. That's where I'll be heading down to Florida for a while. So I can't wait.
Excellent. Enjoy your time down there.
Thank you so much, and thanks for your time. Thanks for tuning in to the latest episode of Court Watch. If you have not subscribed yet, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.